Good morning, and thank you for joining us today as we take a look at the Register of Persons Holding a Controlled Interest in Land, or RCI for short. Today, we'll be focusing on unincorporated bodies when considering a submission to RCI. However, we do also want to briefly introduce you to the background and purpose of RCI, including Registers of Scotland's role. We also want to introduce you to the language of RCI and subsequently whether or not you're in scope of it. We'll also go into some detail on what we mean by unincorporated bodies, their structures, and where the regulations will apply. And we'll look at some scenarios. After that, we'll take a high-level look at what information you'll need to provide, the duties associated with RCI, how RCI is an event-driven register, and then finally look at our guidance articles. By the end of the presentation, we'll have covered the following key stages. Do I need to register? What do I need to make an entry? What do I need to prepare? How do I make an entry? What do I do after submitting? We'll also understand the 30-day period before the entry is published and searchable, and maintenance and updates. So let's get started and take a look at the background and purpose of RCI. We'll first look at who we, Registers of Scotland, are, what the timelines of RCI are, and then we'll move on to more detail about RCI itself. At Registers of Scotland, we hold and maintain 21 public registers, including the Land Register, General Register of Saisines, and the Books of Council and Session. We're a non-ministerial office of the Scottish Government, and the Keeper of the Registers of Scotland is directly accountable to the Scottish Parliament. At ROS, we design and build digital services to enable our customers and the public to access the registers we hold. If you're familiar with us and our work, you'll be aware of some of our key services here, including ScotList and the Digital Submission Service. All are designed to make interacting with ROS easier for our customers. Now let's move on and take a look at the timelines of RCI and how it came about. The Land Reform Scotland Act 2016 gave regulation-making power to Scottish ministers to provide for the disclosure and publication of information about controlling interest in landowners and tenants across Scotland. To progress this, in 2016, the Scottish Government ran a public consultation on controlling interests in land and improving transparency in land ownership. In 2018, draft regulations were laid and Scottish Government consulted on these. Parliament unanimously passed these regulations in February 2021. The register commenced on the 1st of April 2022, originally with a one-year transitional period ending on the 1st of April 2023. Scottish Parliament have since approved an extension to the time period for compliance for RCI submissions by a period of 12 months. Offence provisions will now take effect after the 1st of April 2024. Scottish ministers do encourage everyone who is eligible to engage with the process as early as possible, though, and give themselves plenty of time to register before the new deadline. So what is RCI about? Firstly, it is important to know that RCI is not a register of land. It is, as the name says, a register of persons. This register will make it easier for anyone, whether that's an individual, community body or other party, to find out who has control over the decision-making process in relation to land and property in cases where it is not publicly transparent elsewhere. This means that it will be possible to look behind every category of entity in Scotland, including overseas entities, unincorporated bodies and trusts, to see who controls land. The regulations place a responsibility on owners and tenants to supply information to RCI of their controlling interests. After the grace period for registration ends, penalties will become applicable for failure to register. The regulations are intended to ensure there can no longer be categories of owner or tenant where, intentionally or otherwise, control of decision-making is obscured. It is free to submit to and to search the register. It's important to understand the language used within RCI. This will better help you frame and understand your own situation and may also help you decide if you're in scope. Let me start by saying that when I refer to tenant for the rest of this webinar, I specifically mean a tenant with a registered or recorded lease of more than 20 years. In RCI, we have two parties, the recorded person and the associate. The recorded person is the owner or tenant of land in Scotland. The definition of land can include buildings and other structures. Then we have the associate. This is the person or persons who has significant influence or a controlling interest in the land owned or tenanted by the recorded person. I'll explain what we mean by both of these roles in more detail shortly. Now let us take a look at who will and won't need to register. It might be more useful to first consider whether you may be out of scope of RCI. Owners or tenants will automatically be out of scope of RCI if you are subject to another UK transparency regime. Transparency regimes enable the public to have greater access to information relating to various entities where this information may be obscured. They act as the legislative tool used to help ensure the information is secure, reliable, and accessible to the public. You will automatically be out of scope of RCI if you are already subject to another UK transparency regime that is listed in Schedule 2 of the regulations. As we're covering unincorporated bodies today, it is worth highlighting that COs and SKIOs are out of scope. You will still need to submit if the process to become incorporated is pending but not completed. We've covered transparency regimes extensively on our RCI knowledge base and in our beginner's guide to RCI video, which you'll find on our YouTube channel. So I won't go into significant detail today, but you'll see examples on the page and the link should be clickable also. Broadly speaking, if you decide you're not exempt, it is important to consider the following when deciding if you need to register. In general RCI terms, if you are the named owner or tenant on the title, whether that's on the land register or one of the SAZENS registers, and if there is a person not named on the title but who has controlling interest on the land, then the owner tenant will be the recorded persons and the person with controlling interest will be an associate. For unincorporated bodies specifically, rather than controlling interest, it is general control and management, and I will be defining this shortly. That completes the RCI overview. Today, we're going to focus on unincorporated bodies and how they are affected by RCI. Let's first start with what we mean by an unincorporated body. An unincorporated body is an organization set up through an agreement between a group of people who come together for a reason other than to make a profit. Unincorporated bodies or associations do not have legal personality, and therefore they cannot own land in their own right. As such, the ownership of assets lies with individuals acting on its behalf. These are usually office bearers or management committees. The trustees will be shown on the land register or in the SAZENS register as the owners of the land or as tenants of a registered lease. It is important to note that it may not be noted on the title that they do so on behalf of an unincorporated body. I should also point out here that trustees can differ from those who have general control and management powers. An unincorporated body is generally a small body, such as a non-incorporated charity or another voluntary or community group. Common examples include village hall associations, sports clubs, voluntary groups, and faith and belief groups. The organisation therefore owns the land on behalf of their stakeholders, members, or in the case of a church, people within the church structure. The purpose of separating the information about a piece of land between who owns it and who has significant influence in what happens to it is that the owner or tenant may not be the only one that makes these decisions. It may even be that these parties do not necessarily know the arrangement the land is held on. This is particularly relevant where the original trustees are ex officio, and by this I mean the title sheet refers to a job title or committee position rather than a named person. It is particularly worth noting that for an unincorporated body, when the regulations mention control, the language used is general control and management rather than significant influence or control. Deciding who falls into this category helps establish who would be an associate. This is because of the setup of an unincorporated body and is a key consideration in understanding whether or not you'll need to register. Deciding who can be deemed to have general control or management responsibility is defined by who can make decisions such as sale, lease, or change of use. It tends to be someone in an office-bearing position. It is unlikely that, for example, helping to choose what colour the door will be painted will, on its own, qualify as an associate role. Additionally, standard membership of an unincorporated body will not in itself make a person an associate. It is only where there is responsibility for general control and management. To put this into a scenario, if you're a member of a bowling club but you would not have any influence on whether the building might be turned into a darts club, then you're unlikely to be an associate. Or if you volunteer to arrange the flowers at your local church, but could not influence high-level decisions such as selling part of the land, again, you're unlikely to be an associate. The regulations are quite helpful here. They state that a person is responsible for the general control and management of the administration of a body if they hold an office or other official position in that regard, such as chair, treasurer, or secretary, however that may be described. There are exceptions to being in scope, though, including a paid professional advisor, creditor, or a member of the judiciary set up for the unincorporated body. RCI requires that persons with general control or management of the unincorporated body should be searchable on the register. When it comes to unincorporated bodies, there are two main reasons why you might be in scope. In one scenario, this could be when the trustees are listed as owners or tenants of the land, but actually have no day-to-day responsibility within the unincorporated body structure, which is managed by a separate committee. Another scenario would be that the title sheet lists office bearer titles rather than specific names. This would trigger Regulation 23A, which I'm going to talk about on my next slide. It is expected that each individual body considers their own circumstances against the RCI guidance, and we have some tools to help with that, which I'll talk about later. It's also worth considering whether you may instead update the land register. Once it lists the current trustees and is transparent, there is no requirement to submit to RCI until additional changes are carried out to the unincorporated body, such as appointing a new office bearer, for example. This can be done by registration or rectification, depending on the circumstances. I won't go into that today, but there is guidance for updating the land register on our knowledge base. We recently ran a full webinar on this topic, and there is guidance and a video online, but for those who may not be familiar, just briefly, Regulation 23A deals with the scenario where all the trustees of a trust or unincorporated body named on the property register have left that trust. This might come about if everyone has resigned or are deceased. It also applies where ex officio office bearers are not listed and only their office is named. In this instance, the current trustees are to be treated as the owners or tenants. The duty to register falls on all the current trustees. To be clear, the two scenarios that would trigger Regulation 23A are where all the original trustees or office bearers have ceased to be involved, or only their office is listed. As I said previously, RCI needs to list currently involved trustees or office bearers to meet the requirements. Each of these persons would need to list themselves as recorded persons, themselves again as an associate, and then list any other associates. There is a link on the screen to further information. We're now going to take a look at some example scenarios, and each will ask you to have a think about whether or not there would need to be an RCI submission. For our first scenario, we have the Village Hall Association. It is an unincorporated body. Taylor, Idris, and Ryan are all trustees of the association. They are also named owners on the land register. In addition, there is also a committee of 3 office bearers, which include the chair, treasurer, and secretary. They are responsible for the general control and management of the association. However, they are not named on the land register. Our first answer here is that yes, they are in scope. In this instance, Taylor, Idris, and Ryan would all be recorded persons, and each of them must register each of the 3 office bearers as their associates, as they are not named on the title, but have general control and management roles. For scenario 2, we've got the Kyle of Localsh Bowling Club. Matilda, Ash, and Paul are the current office bearers of the club. They're all named on the land register as tenants with a long lease of 45 years. There are no other office bearers. Some members of the clubs will contribute on decisions such as what colour the buildings could be painted or if they should plant any new flowers, but they have no influence on key decisions. Just have a think on whether you can identify a recorded person or associate here with general control and management responsibilities. The correct answer here is that no, they're not in scope. This is due to the fact that firstly, Matilda, Ash and Paul are still in office and are listed on the title. And secondly, that there are no other office bearers that are not listed on the title. And finally, that the other members do not exert general control or management of the club. We'll now move on to our last scenario. Here we have Bob, Harold, and Norman. They are named as trustees on the Sazians Register for Durness Village Hall Association. They were trustees when the village hall was built in 1930. They are all deceased. The current trustees of the association are Sam, Ash, and Nick. Sam is the chair, Ash is the secretary, and Nick is the treasurer. Remember that we said earlier that where those named as owners on the property register are no longer actively involved, that the current trustees are to be treated as the owners. To decide whether this example is in scope may require a bit more thought. Now for this one, the correct answer is that they are in scope. Sam, Ash, and Nick are treated as the owners under the RCI regulations. This is one of the ones that, especially if you're new to your RCI, isn't typically the most straightforward. This is an example that triggers Regulation 23A that we discussed earlier. All trustees named on the title sheet have ceased to exist. Sam, Ash, and Nick would each need to register as a recorded person. Then, because they're not listed on the title sheet, add themselves as an associate first, followed by the other two. To be completely clear, Sam would register as a recorded person. Then he would add himself, Ash, and Nick as associates. All three would need to do the same. It is also worth reiterating that if Bob, Harold, and Norman had not been specifically named, and the title sheet simply referred to chair, treasurer, and secretary, an RCI submission would still be needed. There are further examples in our guidance articles on both trusts and unincorporated bodies. There are also some excellent examples in the Scottish Property Professional Support Lawyers Group article published in the April 2022 edition of the Law Society Journal. These include examples on SIP purchases and overseas trusts. I'd like to talk a little bit about what online support we can offer. As I've mentioned a couple of times, we have extensive guidance in our knowledge base on our website, and the recorded Beginner's Guide webinar on YouTube is very helpful. We've split our knowledge base into different sections, and we would recommend to everyone to read the articles that sit under Do I Need to Register? These give a more in-depth understanding of what we've covered today and provide a lot more information. Under each article, we've also included the average reading time to help you gauge whether it's one you'll need a little more time with. None of them are particularly long, but we appreciate you're all busy people and we felt it was good to know up front how much time you might need. After reading those articles, we would recommend reading the article on If You Are an Unincorporated Body. It will help support and provide more detail on what we've discussed today. There are a couple of other things I'd like to mention that I think would be very helpful. We now have 4 demo videos on how to submit as a trust on our website, including how to set up an account from scratch and what type of account you should use. This, along with our guidance, is a very helpful demonstration to use alongside your first submission. There is also a video specifically about Regulation 23A, the 5th down on the list from the link on the page, entitled If the Existing Owners or Tenants Are No Longer Associated with the Land. You'll also find a new video, an introduction to our new copy function. We also have our online support tool. This can be used to help you self-determine if you or your client are likely in scope of RCI as a recorded person. This tool can give you an indication as to whether or not you likely need to create an entry. Whilst using the tool, you'll be prompted to answer a series of questions based on yours or your client's circumstances. Once you've completed the questions, you'll be provided with results that indicate whether you likely need to make an entry. Please be aware the results will be dependent on the accuracy of the answers provided and that the final decision should be made by you. This is only to provide assistance. Now let's talk about submissions. If you have decided you're in scope, it's important that certain duties are met and information prepared. For recorded persons, if you are in scope, you must register. You also must verify all the associate details, provide all the details, and notify the associate that the submission has or will be made. Associates need to confirm they're an associate, verify details when requested by the recorded person, and provide updated details when it's necessary. We'll just take a broad look at the submission steps. Firstly, pre-submission checks, including the associate verification notice, which I'll come to. Then you'll make the entry. Once created, the recorded person should download the associate notifications and share them with the associates. And finally, there is maintenance. RCI is an events-driven register, and changes and updates should be made whenever necessary. For example, where there are changes to the trustees, RCI will need to be updated. Also, if any details change, such as an associate's address, RCI will need to be updated. When it comes to creating your entry, the RCI service breaks the journey down into 4 main sections. These include providing details on, firstly, the recorded person, whether they be an individual or an organization, including full name, unincorporated body name, and contact address. The recorded person as an individual is the trustee or office bearers, and it cannot be the name of the body itself. This is because RCI is a register of persons. Then we'll move on to the land, whether it's on the land register or one of the SAZENS registers. Then ownership, which is the capacity in which the recorded person owns or tenants the land. And finally, the associate details, including, if they are an individual, full name, date of birth, although please note the date of birth will not be published or publicly available. It's purely just for internal identification purposes. Their contact address, which can be the registered office. The name in the body is optional for associates. If an associate has previously been added to the register, their associate reference number, or ARN, must also be provided. This is a requirement of RCI. An associate must be notified that a submission will be made in their name prior to creating an entry. We have created a template associate verification notice for this purpose. It's not compulsory to use this. You can use your own, but we thought it might be helpful. All of the information required for this can be found within our knowledge base article on information needed to make an RCI entry. The link is on screen. Furthermore, to help with multiple submissions and based on recent customer feedback, we've introduced a new copy feature. This allows users to create a new submission by copying details from either a draft or submitted entry. This will allow you to select parts of the submission that you want to copy into a new one from recorded person, land, ownership, or associate details. When you're copying details, you cannot copy both the recorded person and land details. This is to prevent duplicate submissions. You can choose to do this from your dashboard, choosing which submission, draft or submitted, that you want to copy. Pick the copy from the drop-down menu, and it will not affect the submission that you're copying from. There is guidance online and the video I've previously mentioned with a walkthrough. After submission, this screen gives you the option to download the associate notifications. It is worth pointing out that, unlike a non-Regulation 23A submission, where a recorded person must notify their associates that they have made a submission, in the case where Regulation 23A is made, the recorded person obviously does not have to notify themselves that they're an associate, although they should notify any additional associates. The associate notification looks much like this. It is the duty of the recorded person or the online services user who is acting on their behalf to maintain the entry. This is done through the Manage an Entry option on the RCI homepage of the service. This includes removing associates, changing any information supplied if it's changed, like a change of address, and if the recorded person ceases to be the recorded person, the entry should be removed. We've pulled out some examples we believe may affect unincorporated bodies where a change may be needed, such as acquiring new land. Do you have AGMs? If so, do you change or appoint new office bearers, or have any ceased to hold office? If this is the case, the new office bearers would need to create new entries, and those leaving their positions may need to remove theirs. Have any of the associate details changed? This could be in cases where they have a change of address, for example. And finally, do you need to remove the entry? Examples where this may be applicable is if you have sold the land or if there are now no longer any associates. We know there is a lot to take in around the regulations of RCI, and we've written some key guidance. This has recently been revamped, so if you've bookmarked any pages, you may need to update your links. These pages will support you in understanding RCI, whether you're in scope and the subsequent considerations if you are. We strongly recommend you read these as they will support you in creating entries. We do review and update our reading materials, so please do keep an eye on these. I'd also encourage you to keep a regular check on our What's New page in service, as this will inform you of the latest enhancements. You will find more information on the copy function I mentioned above, as well as on duplicate associates and combined notifications. We've shared links throughout the presentation, but you'll also find these using the search bar on our website. We've provided feedback links on all of our guidance articles. These can be found at the bottom of each page. You have the option to provide feedback as to whether you find the page helpful, and you can answer yes, no, or yes, but. For all three options, you can provide additional comments. However, when selecting no or yes, but, you can select a reason from the drop-down. We would very much encourage and welcome feedback, particularly as we've made recent changes. Feedback helps us review and update our guidance to ensure we're providing improved support for all. We will now recap on the webinar. Firstly, we ran through the timeline of RCI and then more about the register itself and why it's been introduced. We then introduced you to the language and terminology of RCI, familiarising you with what we mean by recorded person, associate, land, controlling interest, and how to decide if you're in scope. We then focused on unincorporated bodies and how RCI might apply to them. We've also taken a broad look at Regulation 23A and how it might affect unincorporated bodies. We looked at some typical RCI scenarios to help you consider and decide whether the example unincorporated bodies were in scope. We then looked at online support and touched on some of the duties bestowed upon the recorded person and the associate. We finally looked at guidance articles, and further scenarios are written that we hope will help you with your submission. Finally, here are some key links and contact details. A reminder that you can sign up to live webinars on the ROS events pages. Thank you.